Hey everybody, this is Oriana Shea with the Oriana Shea Group, and today I am here with Monica Goel from TLD Law here in Long Beach, and we're going to talk about commonly asked questions about trusts and probates. These are questions that I get time and time again when someone calls me to list their home for sale and they've become the trustee or someone close to them has died and they just don't know what to do next. So Monica is here and she's going to help us out. The first question is basically, what is the first thing someone should do if they're the trustee and someone dies?
Great question. Really, they should take a breath first and make sure that they're in a calm place to be able to start gathering information and to be able to communicate with people. You have to remember that we're all human, and so they themselves are also grieving. So it's important to take some time to grieve and to start collecting information. Transparency from the very beginning is key. Don't let power go to your head. Even if you realize you've been appointed a trustee, don't make it a big power play and let others know that you're the trustee, so you get to make all of the decisions and you have all of the power. These things might be true, but communication, honesty, and transparency help a lot in avoiding suspicion and litigation in the future. So as the trustee, start gathering information. It's important to order death certificates right from the start, and oftentimes the mortuary will help you do this. So I would encourage you to order at least 5 death certificates. You probably don't need more than that. They are fairly expensive, and most institutions don't keep the originals anymore. Once you have the death certificate, then it's important to employ a professional to help you through all of the steps that are needed as the trustee. You're not able to do very much until you have the death certificate in your hand.
Great advice. And I really appreciate the tip on don't let it go to your head and tell everybody that you're making all the decisions, because I can't tell you how many times over the years I've seen this process tear siblings apart.
Absolutely. The thing about it,
They need to feel included, and it really does need to be handled delicately because it gets really contentious really fast.
that's absolutely right. You really nailed it. It's really perceptions and how people feel. And even though they're a beneficiary, they oftentimes feel slighted because they weren't chosen to be the trustee, or they weren't granted the power to be able to control the assets. And so if the person who is granted the power, i.e. the trustee, treats that delicately and allows the transparency so that beneficiaries are included in the process, they won't feel so suspicious and it won't create such tense, bad feelings.
The second question is, what's the difference between a trustee and an executor?
Great question, because people don't understand the vocabulary. A trustee is the person who carries out the wishes that are listed in a revocable trust. The executor is someone who's appointed in a probate estate. So in California, if you're dealing with property, we hope that you're dealing with a trust and that you have a trust where the trustee will administer the trust. But if there's no estate documents in place, then you are probably looking at a probate, and someone in the family will need to apply to become the executor who gets appointed by the court to carry through with the probate.
Awesome. How long does it take to settle an estate?
Great question. So there's a big difference between trusts and probate. So in a trust, it's a private document, so it's not overseen by any court or institution. So once the trustee fulfills their duties regarding notice and the contest period has gone through, then the trustee can proceed with selling property and ultimately distributing the property. And if they're fairly diligent and it's a smaller estate, that can happen in as little as 6 months. But a probate, unfortunately, will often take up to 9 months, if not over a year, simply because you're dealing with the court process and with the court delays.
Yeah, I had a real estate transaction take over 6 months that was in probate.
That's exactly right, because sometimes in the probate process, everything is overseen by the court.
Yeah.
There are different rules regarding notice and the ability to object, which can create quite a few delays. Even if someone as the executor has the power to sell a piece of property in a probate, it might still require court confirmation. And anytime you're dealing with the court, we're talking about significant delays.
Yeah, absolutely. And just to be clear, for the trustee, if there is a trust, and they are, they're named as the trustee and they have a copy of the trust, they still need to follow the steps before they can start liquidating assets in the trust?
Absolutely. I break down trust administration into 3 easy phases. In the beginning, you have to do the proper notifications that are required, and you have to record certain documents on real property and take control of assets in your name as trustee of the trust.
And an attorney can help you with all of this.
Absolutely.
Right? So that's why I tell people your first step should be to contact an attorney. And if you don't know who the attorney was that did the trust, it's okay. You can have another attorney pick up where the trust directs you, and they can help you with the steps needed.
Absolutely. So the trust is a freestanding document. You could take it to any attorney to assist you.
Right.
Oftentimes, the drafting attorney may be getting older, they may have retired, they may not be available to handle the case. And so you should find an attorney that you trust to help you through the process, because the role of the attorney is really to protect the trustee from liability. And so that relationship needs to be a good one and a trusting one, so that you have someone that's guiding you through the process.
Right. If there is real estate in the trust, when can the property be listed for sale? Kind of backtracking a bit on that question, because that's the thing that people kind of rush out of the gate to do.
Right. Great question. So once you have the death certificate in hand, one of the first things that you have to do in order to clear title and marshal the property is to record an affidavit regarding death of the trustee. And the original death certificate has to be recorded in the county in which the property is owned. Once that occurs, the trustee is technically clear to be able to sell the property. However, there's also a notice that needs to go out, and that notice lets the beneficiaries know that they have a specific time frame in which to contest the trust. Now, if you're able to get waivers of that, you can waive that contest period and you can proceed right away with selling the property. However, if there's any question regarding a possible trust contest, I would recommend waiting for that contest period before you list and sell the property, because you need to make sure that there's no contest of the trust before you can then seek beneficiary approval to sell the property.
It really is a good idea, guys, to reach out and start with an attorney, because there are so many steps to this process. And it really can be daunting on the trustee when this happens.
It's a thankless job, to be honest, being trustee, and it's really fraught with a lot of liability. And that's why a lot of times people are hesitant to hire an attorney, because they feel the responsibility of having been appointed the trustee. They oftentimes feel like they don't want to take compensation to save the family money. And if they can avoid hiring an attorney, they'll likewise be saving the family money. However, there's so many landmines involved, and avoiding having an attorney can lead to more cost in the future. So if you hire the attorney from the start, you'll make sure that you're handling everything the right way, and you'll probably save money in the long run.
Piper is riveted, by the way. Okay, and the last question is, what should a trustee do if the responsibilities just become to be too much for them? What are their options?
Great question. One, they should rely on their attorney to help them through the process and see if that alone would be able to get them through. If not, it's better not to take a job that's so full of decision-making and liability if they're not up to the task. So they have a couple of options. Oftentimes, the trust will name a series of successor trustees. So the trustee can resign or decline to act, and then the next person named can act. If for some reason that person is also deceased or unavailable, or the next options are just not viable, the family can decide to utilize a private fiduciary. There are licensed private fiduciaries in California who do this job as their career. They're licensed and bonded, which means they're insured through the state of California. And a professional fiduciary is a great option if the assets are burdensome, or it's a very large estate, or there's difficult beneficiaries. They can navigate through that process and take on the burden of the liability.
Great. Monica, thank you so much. This was great information. I hope you guys found this helpful. If you have more questions about trusts and probates, please reach out. The QR code is on your screen, and I'd love to talk to you. Bye for now.